got you here on camera. You are here, sir. So you are the attorney for the Andreacchio, sir?
Yes, I am.
Wow. Do you want to tell us? I mean, I'm not an attorney. Do you want to give us an idea of what happened with this? I mean, the lady didn't even show up to court, it sounds like, right?
Well, it's a little bit more nuanced than that.
Okay.
So, what happened is we filed a lawsuit against her in summer of 21, and the complaint alleged the various things that Kay had said that we found objectionable,
Hmm.
and we filed a complaint in federal court, and then we prepared a summons, and she was served with personal service as you normally would have in a lawsuit.
Hmm.
And then Kay filed what's called a motion to dismiss. Now, she was acting pro se, meaning she didn't have a lawyer. So she was doing this herself. And she raised her primary objection was the fact that she was upset that we sued her in Mississippi
Hmm.
as opposed to suing her in Michigan, where she lives. But our basis for suing her in Mississippi was that some of the things that she said were actually directed to Mississippi residents while she was on the phone interviewing somebody. So,
Wow.
okay. So, in other words, uh, one of the things she said, and I won't repeat it because it's in the complaint, she she was having a conversation with a couple of guys, and one of the fellas, at least one of the fellas, could have been both the fellas. We thought both the fellas, but certainly one of them was a Mississippi resident. And because she made a contact with somebody in Mississippi while making the allegations that we are alleging, while saying the things in question, she subjected herself to the personal jurisdiction of the state of Mississippi.
Okay.
Okay. So, whereas, like, for example, Without a Crystal Ball and some other YouTubers have sat in their homes in whatever states they're in, bad mouthing people in other states because they didn't necessarily direct their communications to that state by focusing on, by contacting people in that state and making those minimum contacts. Those YouTubers couldn't be sued anywhere other than their home state. But in this particular case, because she made these statements, or at least one set of statements, to a Mississippi resident while on the phone interviewing that person on YouTube,
Right.
she subjected herself to the jurisdiction of the state of Mississippi. Okay.
Oh my God.
Okay. So, because she subjected herself to the jurisdiction of the state of Mississippi, we had the option of filing suit either in Michigan, where she lives, okay, or filing suit in Mississippi, where we live. We thought, why not? We'll just file suit in Mississippi. So she moved to dismiss, and in her motion, she raised. Well, let me back up and give you some more information about how personal jurisdiction works. You have to follow two guidelines as far as personal jurisdiction is concerned. The first thing you have to do is comply with the state long arm jurisdiction statute. So, for example, um, some states like Tennessee and Mississippi have a very broad long arm jurisdiction statute. I practice in both states. Other states have a fairly narrow long arm jurisdiction statute. So, in those narrow states, it's a little bit harder to sue somebody from an outside jurisdiction. Whereas in Mississippi or Tennessee, if you've committed a tort in whole or in part in that state, you can be sued in that state. You see what I mean? Okay.
Yeah.
As far
Yeah.
as the state is concerned. So that's the first box you have to check. But the other box you have to check is the federal Constitution. And under the 14th Amendment to the United States Constitution, just one second, I'm going to make sure I'm on Do Not Disturb.
You're
Uh,
fine.
I'm in
Do you
on my
mind if
phone.
I do you mind if I show, because I just pulled up your website. Do you mind if I show them your website so
Oh, that's
everybody knows
certainly,
where to
yeah.
perfect. Okay. While you're talking, keep going.
So the main concern in an evaluation of personal jurisdiction on a 14th Amendment standard, the first thing you have to look at is whether or not you have minimum contacts with the forum state. And I'll give you an example. Uh, Ma'am, what state are you in, if you don't mind me asking?
I would rather not say.
Okay. All
Can I
right. Well,
just throw out a state? Could I just say
just throw out a state.
I'm
Okay.
going
Because
to throw out New Mexico.
all right. Well, let's say you're in New Mexico.
Okay.
Okay. All right. And let's say you're driving around in New Mexico and you rear end somebody in the car who happens to be from, I don't know, let's say Kansas. Okay.
Okay.
All right. And that person from Kansas wants to sue you, and they go back to Kansas and decide to file suit against you in Kansas. Well, goodness gracious. You've never stepped foot in Kansas. You didn't, direct your negligence
In Kansas.
toward the state of Kansas in any way.
Mm-hmm.
So it would be unfair for you to have to go to Kansas to defend that suit.
Right.
Now, having said that, if you were sending somebody hate messages or sending somebody, I'm trying to think, I don't know.
Verbal hate messages.
Well, I mean, not just. I'm trying to get into a different example that's not from
Mm-hmm.
this case. Let's say,
Okay.
for example, I don't know, you were sending obscene messages or photos to somebody you knew in Kansas, and you
Okay.
were using the mails to do that. Well, then
Gotcha.
you would be subjecting yourself to that jurisdiction, even if you've never been there. You see what I mean? Okay.
Gotcha.
All right. So if you've got the long arm jurisdiction and you've got the minimum contacts, then the Fed start looking at things like, okay, which forum is going to be the better for everybody. So, for example, if all the witnesses are in one state as opposed to another state, if it's more burdensome for the defendant to come to one state as opposed to the plaintiff going to the other state or vice versa, those end up being kind of factors that are added into it to determine whether there's fundamental fairness in you actually being sued there. Okay. And Kay was trying to make those arguments in her motion to dismiss. But where she messed up was that in one of the briefs, in one of the motions, I don't know if it was her original motion or if it was in a response to my brief, I can't remember exactly. She, because she doesn't file electronically, she mailed the briefs. And whenever you file something in federal court by mail, the the clerk takes the envelope and files the envelope with the court.
So she didn't even know how to do just the basic.
Well, no, 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 no. I'm not. No, 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 no. Don't misunderstand me. What I'm getting at is that lawyers have to be hooked into the system to file electronically.
Right.
Okay,
Right. Right.
non-lawyers don't usually have that benefit, so they have to file by mail. Okay, so
Right.
there was nothing wrong with her doing that. Okay, but when the clerks get the envelope from somebody who has filed by mail, they digitize the photo of of the um, um, the pleading, but they
Mm-hmm.
also take a digital photo of the envelope for whatever reason. I don't know why. Well, I was looking at the court records and I found the digital photo of the envelope, and she had mailed the item from Hawaii.
What?
Yes, she had mailed her motion to dismiss, or at least the brief. I can't remember which one. And it was from Express Mail, and it had a postage mark from Honolulu, Hawaii. She was on vacation in Honolulu. And in her brief and in her motion, she was claiming poverty, saying that she couldn't afford to come to Mississippi to stand in a hearing.
Now, wait a minute, Mr. Matt. I- if I was going to be really, really in poverty, Hawaii would be the state. I'm just going to say it's a nice state. You know what I'm saying? It's a nice state.
Now, in her defense, she represented to the court that, well, it wasn't my money, it was my mother-in-law or somebody taking us on a family vacation. And look, having been on family vacations that other people paid for, I understand that's possible.
It's
Okay,
possible.
but if somebody is willing to lay down the money for you to take a plane to to Hawaii on a vacation, why in the hell didn't they lay down the money for you to defend yourself in a lawsuit in Mississippi?
Very true. Hawaii's very expensive.
You get what I'm saying?
Yes,
It's
sir.
like what is it, a 14-hour flight from
Mhm.
Michigan, but it's only an 11-hour drive to Mississippi? Come
Mhm.
on.
Yeah.
So the suffice it to say, the federal district judge denied her motion to dismiss, and he was very respectful about it. And in fact, he said that, you've preserved your objection. Feel free to renew this motion later if you want to. So, okay. So now in federal court, I don't know if you've ever been sued before. If you ever been to court for any reason, have you ever?
Yes, I have, sir.
Okay, all right. So, as a dynamic, let me explain it this way. Federal court is very, very rigid about their rules. They're a lot more rigid than typically state courts are.
Right.
And whenever you file suit in federal court, after people have exchanged answers or after the court has ruled on motions to dismiss, then what happens is the court has what's called a Rule 16 scheduling conference. And let me explain. And I've had a few of these.
Mhm.
I had a federal case not too long ago in Mississippi that was just a run-of-the-mill case. And in that particular situation, my client sued somebody, and we both had lawyers, of course. Both parties had lawyers. And so right before the Rule 16 conference, I call the other attorney. We pull out the form scheduling order and we decide, okay, how many interrogatories are we going to have? How many requests for production? How many depositions? How long is discovery going to be? You see what I'm getting at. Just basically the ground rules for what we're going to do. And if there's
Absolutely.
anything we can't agree to, then the magistrate is going to fix it for us. Usually it's
Okay.
not a big deal. So
Mhm.
you're supposed to meet beforehand with the other party to try to iron those things out. Well, I send Miss Yax the papers, or actually I prepare no, actually what I do is I contact her to see if we could work this out.
Mhm.
And she just blows me off. I mean, it's weird. And
What
so
do you mean she blows you off? Like, because I'm hearing she's not even picking up. She's like
oh,
not
she
even
was
showing up.
responding. Well, she was responding to emails, but she was, it was like she didn't want to have. She at one point, if I'm not mistaken, she actually intimated that she was afraid to be on the phone with me.
Why?
I don't know. I mean, listen to me. I'm flattered that somebody thinks that I'm capable of doing crazy things through the phone.
Sir,
That
you're wearing a bow tie on your website. No one's scared of you. I'm not.
well, gee, thank
I'm
you.
just saying, you look like a friendly. I'm just.
Okay, well, maybe I need to change the image a bit if I
No,
want
it's
to be
great. I'm
intimidating.
looking at the image. I'm like, who's gonna be scared of you? I mean, you're explaining everything as it should be. I just don't know if she was, because as I'm reading some of the stuff and I read the comments, it's like she was dodging some of this. You know?
We'll get to that in a minute. So after you do this, you coordinate with the other attorneys and you have the um, proposed order. You have to have a telephone conference with the magistrate. And let me explain. In federal court, there's two types of judges. Okay, there is the U.S. district judge. And the U.S. district judge is the one who is appointed by the president and confirmed by the Senate and has a lifetime appointment. Okay, and this particular judge, the district judge in this case, is a man, just as a frame of reference. Just happens to be a man. And in this particular case, the magistrate was a woman. Now, a magistrate in this case, a magistrate is sort of an assistant judge. Okay,
Right.
this judge has only an 8-year appointment. Um, doesn't have to be appointed by the president, and the magistrate basically is there to take some of the load off of the district judge. Okay,
Right.
all right. And they're both judges. In other words, you don't go into a magistrate judge's court and show contempt or anything. I mean, you'll be in as much trouble as if you did it in the district judge's court. Okay, but it's just understanding the roles. All right, and so the magistrate judge in this case, she wanted us to have a telephone conference to go over this order and to explain, okay, what, are we going to have, how many interrogatories, how many requests for production, how many requests for admissions, all that kind of stuff. And Karen didn't show up. Karen refused to call in.
Whoa.
Okay. And so I'm just on the phone with the magistrate, and we're waiting 10, 15 minutes. Maybe she'll call in, whatever. So she doesn't come in, doesn't call in.
Oh my God.
So then the judge decides, okay, well, I'll have to put her in, I'll cite her for contempt. So she cited her for contempt for failure to come to this scheduling conference, and fined her $100. To her credit, she paid.
That was the message that was going like viral, something about all she had to pay was $100. Is that correct?
Well, that was the first thing.
Okay.
Well, there's more to come. Okay. Well, then, once you finish that scheduling conference, you can start doing what's called discovery. And that's where you send written questions to the other side, or you can start doing depositions, or you can request productions of documents and things. And we did those things. We sent requests for admissions. We sent requests for production of documents. We sent interrogatories. We sent all of the plethora of discovery that you normally do. And she responded to the request for admissions. I'll give her that. And she moved for what were called protective orders on the other things, where she was basically saying she didn't feel like she needed to answer these things, or didn't want to answer these things, or whatnot. I can't recall exactly what they were, but it's whatever it is. It's a matter of public record. One can go on the PACER website and see this. So she does this. And we have some depositions. We decide to depose some witnesses. And let me explain the background there. One of the things that we sued for was that she had made an implication. She had implied that my client had something to do with the death of her. Well, let me rephrase it. I want to be careful on how I say this. She stated in a communication with various with the people in Mississippi that we're telling about, they were talking about my client having been a healthcare provider, a mental health care provider. And she said, well, that Ray had a client who had a patient who killed himself. Now, I can't say whether or not this patient really was Ray's patient or not because of HIPAA, okay? Can't confirm
Right.
it, can't deny it.
Right. She implied it or something.
But the way she implied it was she put the words together in such a way that it was like, well, Ray had a patient to commit self-harm.
Yes.
Ray had a son who committed self-harm.
Therefore,
there must be something wrong with Ray. There must be something. It was impugning her integrity in that regard. Was our position in the pleading.
yes.
And in fact, if you read the order, that was what the judge picked up on too.
Yeah, that's what I mean. It's in there.
Yeah.
What amazed me is the victim statement to how this impacted her overall.
Well, we'll get to that in a minute.
For sure.
So let's go in chronology, if you don't mind, so I don't go back and forth. So we went through discovery. We and because she had raised the issue of whether or not my client's son had committed self-harm, and obviously our position is that there was no self-harm. We used that as a basis to do some depositions of a few local witnesses, just in case we went to trial and wanted to try to explore that possibility. And Karen was invited to come to the deposition, appear even by Zoom if she wanted to, but she did not appear to, didn't want to appear. Okay, so we proceeded without her. Well, then during this time, she never propounded any formal discovery to us. And said, okay. But we propounded some discovery to her that she never answered. For example, we propounded requests for her, basically any evidence that she had to back up what she was saying.
Right.
And she refused to provide it. In fact, that was some of the things that she was asking for in a protective order.
Oh.
So, long story short, discovery is finished. And the period for discovery ended. And at this point in time, it's about late last year, the magistrate judge ordered that we have a settlement conference. And given how Miss Yax had basically blown off the court about having a telephone conference, the judge wanted this conference to be in person. So she ordered all the parties to come to Jackson, Mississippi for an in-person settlement conference. Well, as that date was approaching, Karen was emailing the court saying, well, can't afford, I don't have the money, I can't do this, I can't do, whatever, excuse you can think of.
Oh my God.
So the judge says, well, listen, I said what I mean what I said. We're going to have an in-person conference, but I'm going to give you a break. I'm going to give you 30 days to arrange for travel. So she continued things at sometime in October. So I live in Northeast Mississippi. I live about 3 hours away from Jackson. So night before I drive down there, I check into a hotel. I get up the next morning. I go to court. My client goes in through, she lives 2 hours away. So she drives to court that morning. Mm-hmm. We get there and, Karen doesn't show up.
Oh my God.
And it's best as we would later find out, and as the court mentioned in one of its previous, in the order granting the default, about the time court was starting, Karen was tweeting, or not tweeting, she was communicating with somebody that, hey, they fined me $100 the last time. But there's no way I'm coming to Mississippi. I'm just not coming.
Oh my God.
So basically she just flipped off the court.
She blew it off.
She blew it off.
Oh my God.
I moved the court for sanctions. I filed 2 motions. I filed a motion for sanctions because I needed to be reimbursed for my time and my travel.
Right.
And for my client's time and travel. And that ended up being a little bit less than $900. And the magistrate judge, granted that sanction. But the magistrate judge didn't have the authority to entertain the next motion that I filed. And that next motion I filed was a motion for default judgment. And I'll explain why I did that. There is, under that Rule 16 I was telling you about, mm-hmm. There's a provision that says that if you don't show up to a scheduling conference like you've been asked to do, the other party or the court on its own motion can, I think actually I take that back. I think it has to be the other party has to move. The other party can move for sanctions. And it makes reference to another part of the rule book. And in that other part, it lists all the various things that you can ask for. And none of the other things would have been a material, or it would have aided this situation, except for one thing, and that was for a default judgment. So I moved for a default judgment. Well, back in May, actually it was earlier than that. It was a little bit earlier in May, probably in April. The federal district judge, the one appointed by the president, I believe he was appointed by President Clinton, or was it Obama? Can't remember. No, I think he was appointed by Obama. The other judge, little aside, the other district judge that I'm thinking of was appointed by President Clinton. In fact, they were law school buddies. That other judge, but not this judge. This judge, I think, was appointed by President Obama. But anyway, he entertains the motion and he files an answer, not an answer, but he files an order granting the default. And he goes into all of the analysis as to why a default is particularly appropriate under the rules of under the precedents of the Fifth Circuit Court of Appeals, which is what governs us in Mississippi. And then he said, okay, we're going to set this for a hearing on damages. Long story short, that hearing for damage was conducted in May. We had that hearing, and that's when I put my client on the stand. And we also played the videos of all the things that had been said online. Now, I'm going to give you some insight to how that day progressed. We had our hearing, I want to say, around lunchtime. And the reason it was around lunchtime was because this particular federal district judge was conducting a federal criminal trial on, I believe it was drug trafficking. So, I mean, there were a lot of U.S. attorneys there, and there was, of course, the public defender's attorneys, representing this gentleman. And so they had an awful lot of stuff going on that day. But the judge wanted to fit us in a break. And so we were doing this during the break, and we spent a good hour, maybe an hour and a half in there doing the hearing. And by the time we were wrapping up, people were coming back into the gallery, other lawyers and whatnot, for that hearing for the big trial. And these, of course, people are not at all interested in YouTube or true crime. They know nothing about this case. And I remember walking out, and I saw one of the attorneys. I don't know if it was a public defender. I don't know if it was a USA. But as I was walking out, you could look and see the look of astonishment on their faces when they heard what this woman was saying on YouTube. Oh my! They
heard the footage?
Yeah, because we had that as evidence at the hearing, and we played that for the court.
Oh my God!
And I remember when I walked out, one of the attorneys to my right looked and said, I wish you luck. Because, and her eyes were just like wide open. It was just, they were just dumbfounded by what had happened. So we presented our evidence, presented our damages, presented the testimony that you read from the victim. And then we just waited for the judge to rule. And of course, the judge ruled this week and gave us the default judgment in question with the amount of money and closed the case up. So that's what's happened in this case.
My goodness. My goodness. So how are you? And one of the questions, and this is a glare, did Ray receive any harassment as a result of Karen's statement? And I believe her job had been called.
That's right. There, and that the court references that in the order. So I'll refer to the order on that. But in her testimony and as reflected in that order, the judge noted that there were, I think it may be on page 4 or 5 of the order. Why don't you go look at that?
Here it is. The court finds Andreacchio's testimony compelling. The mental and emotional toll Yak's false statements have taken on Andreacchio was obvious at the hearing. Being accused of bribing witnesses is one thing. Being accused of contributing to your own child's death is another altogether. Yak's false statements cause real harm and warrants damages. My goodness. So they accused her. Let me go up a paragraph because I read ahead. But Andreacchio explained at length the effects of Yak's statements had on her life in her community. After the webcast, people filed complaints about Andreacchio with the Mississippi Board of Nursing. which opened an investigation and found nothing. People called Andreacchio's employers. They accused her of embezzlement via complaints filed with the Mississippi Secretary of State, which commenced its own investigation and again found nothing. For a sense of how baseless these allegations were, listeners even accused Andreacchio of overprescribing opioids, a class of drug that Andreacchio does not prescribe. This is crazy. Now, sir, you're not a YouTuber, but how do you think about how YouTubers get down at this point when they do this kind of stuff? What are your thoughts?
Well, I'm I think people can get carried away no matter what whether they're YouTubers, whether they're walking around on the street. You know what I'm saying? It's
Yeah, yeah,
the practical reality is that, number one, we have an awful lot of freedom with the First Amendment, and I respect that and I celebrate that. But one thing that you're not allowed to do is to defame other people. So it's important to make sure that that when you say things online, that you can back up what you say with reliable sources, not hearsay within hearsay within hearsay and innuendo and gossip, but literal reliable sources. And then I would also say that if you are purporting to be an impartial person talking about the news or anything along those lines, be impartial. Okay. Don't. I mean, here's an example of what I mean. Neither one of us were around in 1963 when President Kennedy was shot and killed.
right.
Okay?
I wasn't.
No, I wasn't either. But that being the case, we all who know something about history have opinions about what happened that day. There are some people who believe Oswald did it by himself. There are some people who believe he was a patsy for the Russians, or the mob made him do it, or the CIA made him do it, or maybe there was another person who did it. And so there are various different theories about what happened. And as such, every one of these theories rely on some of the facts that have been presented in evidence. Okay. And you can do that respectfully. Okay. But and you can even advocate for any one of those theories you want. But I think what happens sometimes, though, in YouTube is that, moving it back to the real world scenarios we're talking about now, is that you can take one side to such an extreme where you are wanting to destroy everybody on the other side.
Absolutely.
Okay. I mean, there's no need for that.
Right.
All you have to do is present your position, and I think there's something about having a whole bunch of likes. There's something about having a whole bunch of
People.
yeah, and one of the things that you have a responsibility to do to yourself, I suppose, is your goal is to keep an audience and maintain an audience. And to
Absolutely.
do that, you have to produce content that's interesting to your audience.
Right.
Um, and I think sometimes people want to become sensational in what they do in order to attract an audience and keep an audience, because they want to be set apart and different from everyone else.
Right.
And there may be a place for that in some respects, but when you go and you stick your neck out so far that you cross lines that you're not supposed to cross, then you gotta there's got to be some consequence to that.
Absolutely. Absolutely. True Crime Dime says, "Thank you for your time, Mr. Matt. Rabbit, please ask him if she can appeal this, or is it over? What happens if she doesn't pay?"
Well, there is a mechanism for anybody to appeal an order. I'm not going to delve into that because she needs to. I'm for all I know, people she may be watching this, and I don't want to give them any ideas on how to do their job.
Absolutely.
Um, oh, oh, that's a good question. Why was Ray only awarded 500,000 when the suit was for 10 million?
Yes.
Well, the judge wanted to. Well, here's the thing. The most important thing a judge can do when issuing any type of order or judgment is to protect that judgment.
Right.
Okay. And for that reason, I think that the judge, and if you read the order carefully, the judge was not concerned in the latest in the least about any uh, value that we ascribed to the damages. Okay, he needed to look and see what the law and the precedents of other similar cases would permit to allow for that. Okay,
Right.
and I think this judge was being very, very careful not to overdo it, because he wants to make sure that the integrity of this judgment is preserved if there ever is an appeal of some sort. But at the same time, he also wanted to make it crystal clear that what we have accused her of doing is unacceptable and should not be countenanced. Do you see what I'm getting at?
Yes,
Okay.
sir.
In fact, if you look at this order, and I was impressed with what the judge did. So he took a case from 1917
Mm-hmm.
where a person was given $5,000 of damage for essentially the equivalent of what we've accused of today.
Mm-hmm.
Of course, we didn't have YouTube or computers or anything like that 100 years ago. But anyway,
Right.
but what this judge did was he adjusted what $5,000 was in 1917 by inflation to see what it would be today. And he let that be a bottom bound for a minimum amount of the order. And then he took a case from a few years ago where somebody for emotional distress got $500,000 in Mississippi for damages because an insurance claim had not been granted. So he let that be the upper bound. And then in his discretion, he decided what that number in the middle should be based on the facts of this case.
Gotcha.
Okay. So to answer the Glaire's question, it wasn't that he, I mean, like I said, he didn't factor in what we asked for in the slightest. What he wanted to do was to see, it's kind of like, have you ever bought a house? You know how like you get appraisals and they look, okay, well, this is what the house across the street sold 2 years
Mm-hmm.
ago. This is what the house last week sold. This is, okay. Well, that's essentially what the judge was doing to try to get a fair market value of what the damages are.
Gotcha. Gotcha.
Okay.
Yeah.
So that's what he did. And he did that also with the punitives as well. Well, let me put it this way. He didn't actually do that. Let me back up. He didn't assess the punitives based on what other punitive damages were. He came up with that number himself, but it appears to be that he just decided that it would be at about 50% of what the compensatories were.
Wow. This is just, oh my gosh. Do you think that, and this is a question that a lot of people are having, it's kind of the same, but that the client, that Miss Ray will actually, Miss Andreacchio is actually going to collect? Um, what are your thoughts?
Well, you never know how much money a person has until you
Have
start
to
digging.
collect.
I
Yeah.
mean, really. I mean, I've we gave her opportunities to show us the true condition of her finances, and she never did. So, for all I
Wow.
know, she might be claiming poverty. I mean, let me be fair. She might actually be as broke as she says she is. Okay.
Mm-hmm.
Then again, she might be, better off than I am. I don't know. But what I
Wow.
do know is that, you know, um, a judgment can stay on the books for a long time.
Right,
You never know
right.
if somebody's going to win the lottery. So, hey,
That's true. Aaron says, Rabbit asked Matt, do you think that this sets a fine precedence for YouTube, drama, true crime to take note and stop with the libel, slander, and spreading of false info, speculation as fact?
Well, I think it does, but the fact of the matter is, it depends on if anybody's listening.
Yeah,
Okay.
right.
I mean, let's put it this way: there are precedents that are handed down in courts all the time that most lawyers don't even know about until they're researching their next case. Okay. Um, I mean, in the true crime world, in this universe of people who do these types of things, yeah, they've been paying a lot of attention to this case. I understand that, and I appreciate that. Um, and so I guess that's going to be um, a cautionary tale for anyone else. But then again, um, if the bottom line is getting the likes and getting the shares and getting the attention, it may be one of those things that puts the pause on some of this stuff for a little bit, but 6 months to a year, it'll be back to the way it was, because that's just how human nature is.
Right. I truly hope, like, I mean, the lady's not on you. She's not supposed to be on YouTube, right? She got fired from this free app, and I mean, but somehow I feel like people find their way back to the platform,
Mm-hmm.
and it's to have that even tainted on your reputation here. It's just so crazy to me, and that people just kind of keep going. I don't know.
Well, I mean, let me tell you this. Um, just as an aside, many years ago, about 15 years ago, I wrote a book on theology. And one of the things, it was about the Lord's Prayer. And one of the things that I observed in the book is that there are three motivations that govern every single human being:
Right.
the desire for gratification, the desire for validation, and the desire for control. Okay. Now think about this for a minute.
That's deep. That's
Mhm.
deep. It's true.
All right. And, it's something very gratifying when you have a whole bunch of attaboys and likes and comments and super chats, and they're throwing the money at you.
And
And,
follows.
that's right. Okay. And you feel a sense of control because you get to, you know, turn the computer on at 10 o'clock at night, and you're sitting there drinking a Coke and eating your Cheetos, and I mean, and the camera's only showing you from up here up, so you might be in your you might be in your jogging pants while you're sitting
Why you have to
around.
out me like that? Matt, look, I got my Mexican candy behind me. What are you doing?
But I mean that with respect, in the sense that
Right.
you can turn this thing on anytime you want, and if you've got the
Very
audience and you've
true.
got the people that are listening, so you're in control. You're getting the validation you want when you need it. If you're having a bad day, I've seen YouTubers, from the little bit that I watch, they'll get on and they'll start, having a session about how bad their day has been, and this, that, or the other, and vent, and they've got a bunch of live chatters and streamers saying, "Oh, Matt, oh, Bobby, oh, Cindy, you're a better person." You know what I'm getting at, So you're getting the
Right.
validation you need, and with the super chats, you're getting the gratification too, because you're walking away with the money. And if you're monetized, oh my goodness, you can make
You're
this a
making
full-time
money.
job. Exactly.
Absolutely.
So this is the intersection of all three rudimentary human desires, and all I'm doing is trying to put a check on it.
Yeah. Just wow. That's a good way to put it, though.
Hmm?
It's a great way to put. I mean, I never really, but that's wow. That
The
is it's
If you ever get a chance, the book is actually on the website if
okay.
you wanted to look and see. But at any rate,
I'll check it out.
that goes into some more detail.
No, I am intrigued. First of all, I just want to thank you for even hitting the link, because the fact that you said you were the attorney, I said, "Wow." people say whatever they want on the chat. I didn't really know if that was you, but I'm like, let me go check. And I'm like, oh my God, it went into your website. And people were saying in the chat, are you sure he's the attorney? And then I went in there and I checked. So I appreciate you giving us anything. Can I just ask you one more question?
Sure.
Why did you come in and watch out of curiosity? What were you curious to see? What did you think I was going to do today? If you've
Well,
never seen me
honestly,
before, right?
well, no. I just happened to be on Facebook, and I was checking a few things, and this came up saying that you were going to have a show in about 5 minutes, and so I thought I would just
Wow.
monitor and see what people are thinking or saying, and then I realized that when you started talking to people on the Facebook feed was not as
It's not the
pronounced as
best.
other things. That's right.
Yeah.
So I figured it might have been a YouTube thing. So I'll come over here. I see the super chats. I mean the live chat, and I thought, well, stick my head in and give you a little insight of what's going on. You seem like a lovely
Oh my
lady
God.
and nice lady,
Thank
so I'll
you.
go ahead and give you kind of some insight here, so that.
I appreciate it. You gave me an exclusive and I didn't even ask for it, sir.
Well, it's not.
Wow.
I wouldn't call it exclusive. I did this for someone
Oh, you
else a
did.
few
All
days
right. Well,
ago. Yeah.
see, now you almost made me feel better. Well, okay, thank you then.
Well, that's okay.
I didn't book him, Claire. I didn't book him. The link. I didn't know if it was the real attorney, and then I looked into his website. I said, "Oh, he's the real attorney."
Mm-hmm.
Wow, that's awesome. I appreciate you at least giving us some insight because I had no idea. And somebody had sent me the paperwork and said, "Well, let me look into this." And I don't know if you've been paying attention specifically to this community because there's so much going on right now. You had, the Gannon Stout autopsy photos on sale on
Mm-hmm.
Patreon for $3. It's been like one thing after another, and it makes me nervous to be on YouTube to do any type of commentary,
Well, I mean, you certainly have to be careful what you do and what you say, and you
Yeah.
have to be as circumspect as you can. Um, in my particular case, I'm pretty much just telling you what's in a court record and what a judge has already ruled. So there you
True.
have it.
Thank you. SW wants to know, is the husband responsible for Karen's debt?
Um, let me answer the question this way. I'm licensed to practice in Mississippi and Tennessee. The collection of this money is going to be more a function of Michigan law. So we'll have to defer to our local attorneys on that whenever the
To
collection
determine
action
that.
comes. Mm-hmm.
Gotcha. That's a lot of money. That's a lot of
Mm-hmm.
money.
It is. Well,
Do you think she'll think before doing this again? I mean, I would hope she would have learned by now, but I don't know. I mean, I don't know the lady like that. So,
I don't know. Um,
do people usually learn after being sued a couple times? I don't know
I really don't know. I mean, there was a song I heard many years ago, and one of the lyrics goes, the same sun that softened wax will harden clay. Okay, I think that was an Amy Grant song from one of her albums back about 30 years ago. But anyway, basic gist of it is that there are some people you can sue them, and their personal character and their framework and their makeup is such that the heat of the sun will melt them. It'll change them. But then there are some people that lawsuit and that judgment or whatnot will just harden them to go do the same thing over and over again. So I don't
hmm
know. It just depends. It's a function completely of her personality, and we'll
Wow.
just have to wait and see.
Wow. Are you okay if I contact you in the future? Just to
Yeah, sure. Why not?
whether you answer, that's a whole different story, right? But
Yeah, you were.
oh
Yeah,
my gosh.
sure. Why not?
Thank you, sir. I want to thank you for coming up. I appreciate your time and just giving us that other perspective that nobody was going to get out of me reading the documents, if that makes sense.
Well, I thought I'd just go ahead and do that. And
Thank you.
you seem like I could tell that you were a very pleasant person, and I thought I would just give you a shout out and see you know what your fans or whatnot, whatever you want, followers, listeners,
Supporters, for
supporters.
sure.
That's the word we're looking for. Would
Supporters.
have a little bit of, because here's the thing I want you to understand, and I'll leave you with this, okay? I am an advocate for my client, um, but I'm also an attorney, and as an attorney, I have a duty to represent or to protect, let's say, the interests of justice, okay, and fairness. And so, I, I don't want, I don't want people to go and, misunderstand anything in this judgment or in this order and unfairly run Karen's name in the ground. You know what I'm saying? Okay.
Yes.
Um, you know, this is this lawsuit is about something that she said about my client that was, um, more reprehensible, that we thought was very reprehensible, and we wanted to hold her to account for it. Um, but at the same time, you know, um, you know, I, I wanted to make sure that you had a complete picture before you know, I didn't want you to misunderstand anything in the order or whatnot, and then give the other side uh, an unfair shellacking. I mean, give them a
Absolutely.
shellacking, but just make sure it's fair.
No, I appreciate you. And I mean, everybody is appreciative of you. I'm going to put your information in the description box. So if people have more direct questions, they can just contact you. If, people want to know the name of the book too, by the way,
Well,
if you want to,
the name of the book is The Godly Path of Least Resistance, and there's a link to it on
in the
the
website.
website. Yeah.
Okay, great. And I will put that in there so you guys can check it out. Thank you so much, SW. She says, Rabbit is awesome. We appreciate you, Mr. Matt. See,
Have a good night.
you're awesome. Thank you so much for
All
stopping
righty.
by, sir.
Bye bye.
Bye. Wow, that was awesome. I did not expect that. You never know who watches you. That's for one. You never know who watches you, who will push your link. My goodness, that was awesome. Thank you again, Mr. Matt, for explaining that and breaking it down so that all of us non-attorneys can understand that. I'm having to head out, you guys, because I got a little baby bunny over here. But thank you so much for your support. And make sure you share, hit that like button. I might have to update the title here so that it shows that we actually spoke with Mr. Matt. Let me know your thoughts in the comments if you're watching the replay, and I'll see you guys tomorrow. We got a full day of content. All right, bye guys.